lover of law.
A different kind of high, you know. Feel me on this.
Damn, I love you like the light, the ganja, since the music, can I feel ya? All I wanna do is touch ya, the ultimate rush, the drug baby. Damn, I love you like the light, the ganja, since the music, can I feel ya? All I wanna do is touch ya, the ultimate rush. Damn, I love you like the light, the ganja, since the music, can I feel ya? All I wanna do is touch ya, the ultimate rush.
As the governor refuses to act on the will of the people, it is essential for the judiciary to step in and provide the required recipe for so many suffering individuals. It's been 17 years since the Camden County Drug Task Force arrested me and launched me into this activism. For years prior to that, I believed in the legalization of marijuana, but it wasn't until I was actually arrested, my life was on the line, and I was ruined with arrest for a plan that I came out fighting. And I've always looked at this fight as it wasn't just about me, it was about the law, changing the law, changing public perception. Calling myself Njweedman was all a plan. Petitioning to change my name to njweedman.com was all a plan to get name recognition, to get people to come to my website and see what I gotta say. But after 17 years, I finally reached the pinnacle of my activism with this appeal that was filed on March 18th, 2014. And this comes from my case where I was arrested in Mount Holly on April 1st, 2010, April Fool's Day. And I said then that at the end of this case, it's going to be the state of New Jersey that was the fool for arresting me. Now, I have standing in this case because I got prosecuted. I have two charges: possession with intent to distribute and possession. The possession with intent to distribute, after 2 trials, a hung jury, and then a not guilty verdict, I was exonerated of that by a jury of my peers. And I really feel that the jury rejected the law because I clearly was guilty. I was also convicted of simple possession, which a conviction is bad, but you know what? It was good in my case because it gave me standing to bring my legal arguments to the appellate court. Because I felt like, first of all, I was prosecuted unfairly. I'll mention exactly how, but the fact of the matter is, most laws in America, believe it or not, most social change in America has come through the courts. People like Christopher Christie, our governor, he thinks we rule by fiat. All he talks about is vetoing the legalization bills. You know what? Hey, anything comes across his desk, you're right. He can veto it. He has every power in the world. The state of New Jersey, our governor is a very powerful person. The way our state government allocates its executive branch. But you know what? There's also a judicial branch. And that's where I'm going. And this has been my quest for a long time, to get certain issues before the appellate court and let the appellate court decide it. You know, for instance, in this appeal right now, my very first point, I want you to recognize this, that I'm just claiming that I should have been allowed to use the medical necessity defense. And our medical necessity defense in New Jersey is based on a 1986 case called State versus Tate, T-A-T-E, State versus Tate. Now, in the ruling, the state appellate court said they hypothesized about a future patient who had a state card from a they hypothesized about a future defendant who would have a regulated medical card, about a patient who was authorized by their doctor to utilize marijuana, who had a condition that the state and the government recognized as being helpful with marijuana. So in 1986, the state of New Jersey envisioned that there would be people like this. I am that person. This case gives me standing to challenge the ruling in State versus Tate. Since 1986, there hasn't been a solid medical marijuana argument in New Jersey. And this is it. My point number 2 also is about medical necessity defense. And it's also a religious argument in the sense that I was denied expert witnesses. That's what my point 2 is. I was denied expert witnesses to assist me in my trial. Now, this has nothing to do with marijuana, in all honesty. This is a Sixth Amendment argument. I have a right to certain things, a right to assistance of counsel, a right to be presented witnesses in my behalf. I was absolutely denied the right to have expert witnesses. So that's an issue that's going to be raised in this appeal. It has a direct impact on, say, jury nullification. If you want to argue the law is wrong, you need expert witnesses to come help you. And, you know, in my case, I was denied that. It has nothing to do with marijuana, other than the fact that the state and the judge didn't want me to present this case that the law was wrong. We all know the law was wrong, but they weren't going to let me present the case that the law was wrong. Okay. My point 3, again, goes to due process. Basically, due process arguments based on the fact that I had, once again, a medical marijuana card from another state. I was a resident of another state, and I was visiting New Jersey at the time of my arrest. And I don't know, I believe the state of New Jersey is wrong in not respecting my right to travel, not respecting my right to be safe. Why does my treatment have to change when I pass the borders, cross certain borders? Anyway, an argument I don't think the state will actually win on appeal. I think that's a no-brainer. I think, you know, we live in the 21st century now. People fly back and forth across the country, move state to state. Maybe it wasn't even thought of in 1776. But at this point, it's every day. People travel all over the place, and you shouldn't have to have 50 different rules and regulations for your medical, you know. For each different state you go in, you have to get a different rule and different regulation. No, I think the appellate court's smarter than the judge in my case, and I think they're going to realize that this is an area that needs to be talked about and explored and needs to be regulated. Like, once again, as Mr. Christie doesn't know, the judiciary has just as much power to legalize or regulate a law as he does, actually more, because an appellate court ruling creates law. In this case, which I say is the most important marijuana case in the history of New Jersey, is going to create law. It's going to create change. Again, my point 4 also goes to a religious argument, And a religious argument that marijuana is a sacrament is a religious item that the state is violating the First Amendment, basically, and outlawing flat out the sacrament of the Rastafarian faith. There are no cases in New Jersey dealing with this, so this becomes a first, and it becomes, case law, whether we win or lose. There's going to be an appeal on that issue, no matter which way the appellate court rules. I'm pretty sure of that. Point 5 was again part of that. Same thing. Point 6 deals with the 14th Amendment, deals with scheduling issues. Marijuana statutorily is a Schedule I drug, but the definition statutorily says that marijuana has no medicinal value, not accepted medical by a doctor, blah, 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 which factually is not true. Which, again, this point is going to be challenging directly the scheduling of marijuana. Like, I don't know, I think common sense, most people, when you look at it in black and white and compare marijuana to the definition of a Schedule I drug, it doesn't fit. Steal one from Johnny Cochran, if it doesn't fit, you've got to acquit. All right? And then again, and I'm also asking for my marijuana back too. I think that the state's statute, our 2C statutes, were null and voided anyway when the state initiated its Medical Marijuana Compassionate Use Act in the first place. I believed on the same day that the state of New Jersey enacted that law, what it did was null and voided, made obsolete the state's 2C laws because it directly contradicts it. You have one law saying marijuana is now recognized as a medicine, our marijuana law from 2010. And then on the other hand, we have our 2C laws that were updated back in 1997 that say marijuana has no medical value and therefore it's illegal. You can't have two laws. And you say, well, there's 20 other states that have legalized marijuana. Well, let me tell you about the other states. All the other states have made amendments to their state criminal law. The state criminal laws of California have provided an exemption, and the exemption is the laws that were created by Proposition 215, the 11625 statutes. These statutes these laws are contradictory. You have one law saying marijuana has medical value, you have one law saying it doesn't. Again, contradictory. I believe that the state of New Jersey actually was the first state to legalize marijuana, although inadvertently with that. And it was exacerbated by the original mistake. Okay, we know Governor Corzine signed the bill, the law, the last day he was in office. Christie came in and just started trying to block the law. He should have fixed it. He could have amended our state criminal statutes like other states have done. He could have amended our state criminal statutes and allowed for the medical use within our criminal statutes, but he didn't. Instead, he tried to block it. In the meantime, we have two state laws. Two state laws going, people have been arrested for a substance that the state says has no medical value under our 2C laws, as they are giving marijuana to other people under different laws. And they're contrary, they're clear violations of our equal protection. And I believe even on those grounds, as far-fetched as it seems, I believe the appellate court, when they look at it, look at the law, look at the precedent, forget this is a marijuana case. If there was a law that said you can make right on reds, and there was a law that said you cannot make right on reds, the law that says you can make right on reds if it was the law that was passed last. It would supersede and render obsolete the law that says you can't make right on reds. Well, the same thing with these two marijuana laws. You have this one law, the older law, that says marijuana has no medicinal value and is therefore illegal, and people go to jail for it and all that. And then now you have this other law that comes right in, directly contradicts that, and says we now recognize marijuana has medicinal value, and we're going to provide people with it, allow them to get it, and blah, 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 blah. How are you still arresting these people? Clear violation. Anyway, these are the issues that I am presenting, and if you listen to this for this long, just imagine I've been wanting to say stuff like this for 17 years. In the beginning, I want people to go back and look. I have filed these arguments before, but I didn't have standing, because you know what used to happen? I would go smoke a joint at the state house. I would try to bring these religious arguments. I would try to bring these scheduling arguments before the appellate court, and some prosecutor would look at it and decide, no, we're not going to give him that soapbox, and they would dismiss the case. So I used to have all these little smoking things where I would go places, and this campaign of smoking where I would smoke places that they would dismiss the case. It happened in Burlington County at the courthouse. But in this case, 2010, when I was arrested on April Fool's Day, Mr. Luciano couldn't pass this up. He had to prosecute me. And what we got now is a good old-fashioned whoop-ass by a defendant. Now, I feel like I already won the case. I'm not in prison, for one thing, and I still get to appeal, and I still get to raise all my constitutional issues. Sure, Judge Delahaye got a little persnickety on me, and sentenced me to 270 days, but hey, it wasn't a death sentence, and I'm still here kicking, and I'm still fighting, and I ain't shutting up until it's legalized. The reefer revolution won't be televised. It's already digitalized. I've been telling the man to go to hell in HTML. Njweedman.com. Read my appeal, bitch.